Until the Attorney General, Godfrey Yeboah-Dame, follows through with his declaration to file an appeal at the Supreme Court, the accused persons in the highly publicized ambulance procurement trial, Dr. Kasil Atoforsen and businessman Richard Jakpa, are free. What has been lost again is that the state has lost the opportunity to have secured the 2.37 million euros that were lost due to the processes leading up to the procurement of the ambulance and how the ambulance came in and were unfit for purpose at the time. The state had the opportunity when Big C proposed that they were willing to pay the amount to the state, but the Attorney General and prosecution for that matter declined that offer. Today that opportunity is lost. The states cannot go back and secure that $2.37 million. It has now been lost to the state.
Earlier said, this ruling is a victory for all democracy-loving Ghanaians and those who hold fidelity to the rule of law, to the law. So it's a victory for all Ghanaians. It's not a victory for me alone. And for all those who were praying and they saw that we needed integrity in this country and they wanted that protected. And so it's a victory for everyone.
When I spoke with you during one of your interviews here at the court complex, you mentioned that the judge was treating you like a convict who is only going through the motion, and then at the end of the day you're going to be thrown into jail. Do you regret that statement now that the case has been, taken off by the Court of Appeal?
Not at all. I stand by it because it's a fact. It was very obvious and clear. And the justice that I got with all Ghanaians supporting it, I got it from the Court of Appeal and not from the High Court. The High Court, if you realize, we sat yesterday and we're to sit today, Tuesday, and we're to sit Wednesday. So you could see that she's in a hurry to finish this case before the election.
The Attorney General has since vowed to appeal the Court of Appeal ruling, which he describes as perverse, grossly unfair, and erroneous decision at the Supreme Court. Richard Jakpa says he is ready for that.
I'm always ready. If the Attorney General wants to go to the court or go to the Supreme Court to appeal against the ruling, I'll meet him there. Even if he doesn't win there, he wants to go for review, I'll meet him there. Wherever he wants to go, I'll meet him there. So I don't have an issue at all. I'm really ready for this government. I'm ready for them.
It remains to be seen if the Attorney General will indeed appeal the ruling or not. Richard Jakpa left the court complex happy and full of smile. Dr. Kasil Atoforsen, Sylvester Animana, and Richard Jakpa were dragged to the High Court in 2021 for willfully causing financial loss to the state and misapplying state property.
The minority leader, Dr. Kasil Atoforsen, was greeted into the chamber with tears and chants from his NDC colleagues who had white cloth draped around their necks. All this in celebration of the acquittal of Dr. Kasil Atoforsen and businessman Richard Jakpa, who were both standing trial for allegedly causing financial loss to the state. The former minority leader, Haruna Idrisu, explained all this to the House, stressing the Attorney General will be further embarrassed if he pushes through this appeal.
The Court of Appeal upheld that the decision by the High Court for him to proceed with a submission of his case had no legal basis, and therefore they not only discharged him but acquitted him. That is what we are celebrating, and he's invited to celebrate us. Now, Mr. Speaker, I hear the Attorney General, even instead of swallowing his humble pride, is saying that he wants to litigate on this matter Mr. Speaker, we assure him that he will be further disgraced.
Majority Leader Alexander Afenyo-Markin said he shared in the victory of the minority leader, but insisted the NDC should stop attacking judges whenever judicial decisions don't go their way.
We have to be very consistent as a political class in our celebration of the judicial. Mr. Speaker, I agree with the position taken by the Honorable Harry Nedrisu. No executive arm of government can manipulate the judiciary arm of the realm. Mr. Speaker, it must never be said that the judiciary is under the control of the executive. Mr. Speaker, I celebrate in your victory, and you know how much it means to democracy in this country. Minority leader on trial, you've gone through the system, your belief in the judicial system. Today, on all fours, I don't take alcohol, but I can offer you a non-alcoholic wine. Mr. Speaker, I know Atu doesn't take alcohol either. No, I don't. I have serious allergies. Oh, we are not talking about other things. Mr. Speaker, I know Atu doesn't take alcohol either. Anytime we go for lunch, it is fruit juice.
Parliament is set to go on break at the close of business today, and the latest development would have been expected at the start of this meeting, when a trial threatened to handicap Parliament in the delivery of its mandate, when the NDC announced boycott whenever their leader was in court. Reporting for Joy News, Kweku Asante, Parliament House, Accra.
I'm a firm believer in the rule of law. I'm an adherent to the rule of law, and clearly our appeal against the decision. This is the first time that a decision adverse to the prosecution has been given by a court. Remember when there was an order after we had led so much evidence against Dr. Opini, the High Court actually ordered that we should commence de novo. What did I do? I filed an appeal to the Court of Appeal, and I was able to sustain the appeal. And so I think that is what we've done promptly in this matter. We'll file an appeal to the Supreme Court for the Supreme Court to give a definitive view on the matter. And I think that clearly this decision by the Court of Appeal is wrong, is unfair to the nation, and must not be allowed to stand. If indeed it stands, it will set a very dangerous precedent for the nation. It goes against the grain of all the authorities on causing financial loss in the country. And in my respectful view, there is no case in which financial loss has been more clearly established than this one. The financial loss established, and also as a result of the act of the accused person here, is so clear. You find an accused person who even profited 700,000 euros out of the 2.3 million euros that was paid for the ambulances. I mean, I think that this is so offensive to the rule of law, and indeed, the decision must not be allowed to stand.
Bar is that those words were inappropriate and unnecessary, because if a decision did not go in your favor, you could try to appeal against it, which he indicated. So those words were not necessary. Don't forget, he's the leader of the bar. Words like that should not be used to describe judgments of a court or rulings of a court. We all must believe in the system. Assuming this decision had gone in his favor, would he have used those words? I am sure no. If you remember, in 2022 at our conference, he was one of the people who spoke against former President Mahama's description of the Supreme Court's unanimous seven. So for us, we did not expect him to use such words. The least we expected of him was to say that was a decision of the court. He would apply for the decision, review it, and advise himself. I think that would have been more appropriate.
But this case is over. I mean, as far as the appeals court is concerned, once it's out of the courts, you can say anything, can you not?
No, what I mean is this. Evans, those words are just too strong. That's why I ask, assuming the decision was made in his favor, would he have used such strong words? Illegal, perverse? No, he is the leader of the bar. We shouldn't expect him to be using such words. You could say you disagree with the verdict of the court and you take steps. I think that's what everybody does. But as the official leader of the bar using such words, we take an exception to it.
Actually, I knew he was going to be vindicated because he's innocent and he did the right thing. He never did anything wrong. For them to accuse him of it, I know they were just going back and forth, and I know the government just wanted to use him as a scapegoat, which was not going to work. We knew we were going to win this case hands down. We knew we were going to win it from the onset. He's innocent, and it has been proven today. A sitting government is afraid of him. He's a very strong person, and they know the impact he has on the NDC and the followers he has. So they wanted to sabotage him by bringing court issues to him, which was not going to work, and we knew he was going to win this case.
You know, Atufose is our mentor, is our everything. He has done a lot for the youth of this town and in this constituency. They have secured jobs, development, everything, everybody knows. So when this issue came to court, we were very disturbed, especially those of us who follow Atufose. And I think this is a victory for the constituency, a victory for democracy, but everybody knows that Atufose doesn't supervise the work of Ministry of Health. Ministry of Health is autonomous. He's just a minister at the Ministry of Finance. And he just did something that we call, it is mandatory. It is what the Constitution obliged him to do. So we are very grateful to the motherland. We are very grateful to the courts. We are very grateful to those people who supported Atufose through that trial. And we are very happy that our member of parliament, which is our father, our everything, is now acquitted and discharged. And I know when the law says acquitted and discharged, no court can call this case again.
There was no case at all. We are expecting a more formal way of legal actions to be taken, especially when somebody is a master of the law and then they tend to go or breach the law. I'm saying Dr. Atufose, from the beginning we know he was innocent, but the processes and some of the actions of the legal practitioners, I think it is a time the highest court of law, being the Supreme Court, takes such actions, especially when the master of the law goes against the law. And I must say emphatically that Atufose has been innocent from the beginning. Whatever plots it was to take him anywhere wouldn't succeed. We knew from the beginning. So it's not a shock news, even though we are jubilating within. It's a good day for the victory of the NDC coming up. But we also urge that further proceedings or further investigations should be done so that any master of the law who went against the law could be called to action and punished for the illegal acts against the law of the Constitution. Yeah.
Well, welcome back as we have that all-important conversation. You can tell already by the numbers getting on to watch that you are very interested in this subject. So we asked this morning, is the NDC prepared to go the long haul with the AG, whom they accuse of treachery, as he vows a prompt response at the Apex Court upon the acquittal and discharge of Atufose and Richard Jakpa at the Court of Appeal? You know, there was that subject of whether there was a cause for that action taken to the Court of Appeal and a no-case verdict by 2-1. That was the verdict of the court. We'll get into all the conversations, but let's quickly bring in our guest this morning. Bobby Banton is a lawyer. We also have joining the conversation Inus Afuseni, also a lawyer. He's also member of parliament, former member of parliament for Tamale Central and former ranking member of the Constitutional, Legal and Parliamentary Affairs Committee of Parliament. Gentlemen, good morning. Do we have Bobby Banton? Do we have Inus Afuseni? Good morning.
Yeah, you have Inus Afuseni.
All right. Let me just check for Bobby Banton. Bobby, good morning. If you can hear me, please unmute, Bobby. Okay, I think I see your lips saying I am unmuted, but I can't hear you.
Wow.
Okay, I can hear you now. I can hear you now.
You can hear me now. Okay.
All right. So, gentlemen, I want us to lay a quick foundation for this because there are so many issues to get into. What did you make of, first, the Apex Court's ruling yesterday, and second, the reaction by the Attorney General's Department, specifically that letter that was written? I'll get into some salient parts of it, but how did you receive the news? I'll start with you, Bobby Banton.
Well, I've had the privilege of reading the decision, both the lead majority and the dissenting.
I think they both did a good job in respect of the appreciation of the law. You would notice that they all used almost the same cases to justify, authorities, to justify their position, applied it to the same facts, the same evidence that they all refer to, and yet arrived at different conclusions. That is the beauty of the law. I think there are interesting legal questions. Prominent for me is, at what point does the burden of proof shift on an accused person in criminal proceedings, particularly when there's an averment, a positive averment and a negative averment? I think that is a main point of discussion, and I would want to see how the Supreme Court, if indeed the Attorney General pursues the appeal as he has indicated, would make a final determination on that subject. Now, as to the reaction by the Attorney General, I agree with those that have said, and I have said yesterday, that I think that he could have avoided some of the words he used, or he could have made his point without necessarily using those words. Indeed, if you're not happy with a decision of a court, you have a right to appeal. There are rules that govern even the grounds of appeal. For example, the grounds of appeal cannot be argumentative, vague, those kind of words. You cannot use words that connote that as if the courts that rendered the decision intended there was a malice, because if you use words
or maybe was incompetent.
Well, if you say the court was incompetent, you mean that the court, not the judge, because you are dealing with the court. Jurisdiction is assigned to a court, not a judge. If you say that the court was incompetent, loosely, you are saying the court did not have jurisdiction. But if you use words like perverse, for me, the ordinary meaning indicates that a concerted effort to intentionally divert the course of justice. And you will not, as the leader of the bar, want to describe publicly the court in that words, because what it means is that you are also in some form eroding the confidence that ordinary persons would have in the court. If you say that this is a decision against the country's fight, it's as if the court is separated from the country and the court is going against the country. But as the Attorney General, you have equal right to the court like the ordinary citizen. And so those words could have been avoided. Nobody disputes the right of the Attorney General to appeal. In fact, in criminal law, your one main ground of appeal could be that the judgment is unreasonable based on the evidence that was adduced. So the law allows you to use the words judgment was unreasonable based on the evidence that was adduced. But the moment you introduce words that connote malice, then it becomes something that is regrettable.
All right, I'll come back to that point of the AG's statement. And of course, it was after I used the word incompetent that I realized that generally it has a legal meaning. But I was looking at a more specific meaning, looking at the judges themselves. But let's and that is outside of what we're discussing. But let's look at Inusaf Hussaini. I want your initial appreciation of what happened yesterday, because I will come back to both of you on that reaction of the AG as well. Inusaf Hussaini.
Much I think that I agree largely with Bobby Johnson. I think that the Attorney General went overboard. Decorum should admit whatever happens in court, and even the statements of the Attorney General. And in this particular case, it appears that he let decorum fly through the window. The time-tested position or statements that we have known Attorney General to say is that he respects the decision but disagrees with it, and that he will take steps to challenge the decision of the court. And that ends it. I mean, if you say so, you are showing maximum respect to the court, but I disagree, and it's an opinion of the court, and you are allowed to disagree with the opinion of the court and test your opinion against a superior, court, and that is the Supreme Court. But to say that the judgment is perverse, and all that the words that he used were uncalled for and ought not to have been used, especially as leader of the bar. And more especially, this case having gone through some tumultuous times in the past. And so for me, I think that it's good that the Court of Appeal has said that in their view, by 2-1 majority, that the trial court got it wrong in the case, in the submission of the case made before it by the counsel for the first and the third accused person, and that in their view, Article Section 11 of the evidence degree ought to have animated the consideration that were these lingering doubts, which were not answered by the by the prosecution, which clearly could lead. If the accused person refused to open their defense, could those facts that have been adduced lead the court to pronouncing judgment on the accused person? The court of appeal was to review that clearly that test had not been met because they were still lingering down.
I see. Well, Sweetie Abochi.
Yeah, I'm just wondering where we draw the line. Yesterday, I was listening to the Deputy Attorney General, and in his defense of the words that the AG actually used to describe this, he said that he's not describing the court as perverse, but the judgment itself. So my question this morning is, where do we draw the line between criticizing the judgment itself and criticizing the system that the AG actually leads? Are we criticizing the AG because he's calling the judge, he's describing the judgments, which obviously doesn't sit well with him, as perverse, or are we saying that he's critiquing the entire system that he leads? Where do we draw the line? Mr. Hussaini.
It is precisely because of this confusion and difficulty in drawing the line that we have the professional ethics rules and the conduct of the Attorney General in court. That, look, as the leader of the bar, you must at all times be aware that your words, your conduct will come under the hashes of life. That when you use words, which words do not show respect to your office, that people will criticize you. And so the Attorney General ought not to have used those words for his deputy to come back to defend the use of those words. It's very important to note that. To come back to defend those words means that, those words ought not to have been used in the first place because it's attracting attention and condemnation. And so for me, it is neither the case where a person can argue that, well, we are not attacking the judges. We are saying that the judgment is a matter of opinion of the court. And you can see that clearly even from the 2-1 decision, that one judge was of a different opinion. But it's a democratic court. So 2 judges were of the same opinion against one judge. If the other judge, who was of the opinion with the majority that led to the acquittal, switched sides and followed the dissenting view, the judgment would have been different. And we all know that there might be compelling reason for an Attorney General to go back, or for the prosecution to go back to court, the Supreme Court, in a case of this nature, a 2-1 decision. Right. So why will you use those words when you know that you have the right of appeal to come back to defend or explain the use of those words? So, my dear, I'm saying that the Attorney General, as leader of the bar, must at all times be aware that his conduct, his statements, his actions will come under the hashes of life when those actions are exhibited.
Staying on that same front, I know both of you gentlemen have read the ruling of the Court of Appeal. Bobby Banton, you made mention of that earlier. I want to believe, you say that both of them, both the ratio decidendi and of course that you understand from both sides because they cite the same case law among others, authorities. And I know that you definitely, Inusa Fuseidu, will be in support of it. But let's look at the wording microscopically, okay? He says the ruling is inimical to the fight against corruption, the abuse of public office and all of that. But the use of the word perverse was what hit me the most. And I want to just expatiate on that. If you look at the Cambridge Dictionary, it has 2 definitions online. Perverse as an adjective meaning strange and not what most people would expect or enjoy. But then the second meaning, having the effect of being or intended to be the opposite of what is usually expected or considered reasonable. Underline reasonable. Another dictionary I have is harsher. It says in its second definition of the word perverse, morally wrong, evil, wicked, perverted. Note those words. So the first one alludes to a lack of reason. The second one, morally wrong or evil, wicked, or perverted. Now, my question to you, especially as Xavier Kuje, who speaks for the Ghana Bar Association, has said that this was wholly unnecessary, especially considering that the same Godfred Yeboah-Dame, when former President Mahama described the Apex Court as unanimous 7, unanimous FC and all of that, Godfred Yeboah-Dame railed against that. I'll start with you, Bobby Banson, on those specifics and the calls for Godfred Yeboah-Dame to face some punishment. What is your take?
Ben, you know, one regret that I have about this whole matter is the fact that some way, somehow, the conversations always end up being around the person of the Attorney General instead of the should I say, the suit or the criminal proceedings and the principles of law that is being applicable. That whether intentionally or unintentionally or for political expediency, unfortunately has come to be the main. So it's more or less centered about him and what he says in respect, and it takes away a lot of the focus on the real issues at hand. I wish that it's the narrative change, but unfortunately it is what it is. I like I said, I wouldn't have used the words he used. It doesn't mean that he's still not the Attorney General. He was appointed by the president. In the past, when the allegations of him conducting himself in a manner that was not expected of his office by dealing with an accused person and advising him to go and take medical report and what have you, he still, stood his grounds. He still went ahead to do his case. The executive that appointed him did not indicate that they would take any step in respect of that. So unfortunately, we are where we are. I do not think that he would consider resigning or stepping aside, or even, I heard in some quarters that he should not even be allowed to address the bar at this year bar conference. I do not expect him to give in to those demands. Whatever it is, I am sure that with hindsight and with good counsel, perhaps he would perhaps come out to say that some of the words he used are harsh. He would rephrase them, apologize if need be, and then so that we can focus on the real issues at hand. If he doesn't give an apology, well, the jury is out there of everything that has come to play so far. But I would wish that, like the High Court judge advised, that because of the nature of the allegations that have been made, some of the statements that has been made, the allegation that he has not denied, the conversations that he had with Mr. Japa, she advised that it would have been good if he personally does not get involved in the prosecution of the case.
Right.
Unfortunately, he insisted that he will go ahead and be personally involved.
Right.
And some of the comments that he has made shows as if to suggest that he has, a personal interest in the matter, which I do not think that may be.
Bobby, pardon my sincere apologies for this. Just hold for me. We've been able to get the Deputy Attorney General, Alfred Chiayeboah, a Deputy Attorney General, Alfred Chiayeboah. We want to hear from him briefly. I'll come back to you, Bobby, when I'm done, and then to Inisa Husseini. Senior, good morning.
Good morning, bro.
It's good to have you join the conversation. I know you've been talking on this matter, but since yesterday, the appeal court's ruling was out there, but instead of focusing on what it says, many people are now talking of the reaction from the Attorney General's department. What is your understanding of the ruling and the response? Do you feel people are right in the sort of backlash your department is receiving?
All right, thank you very much. Yes, yesterday the Court of Appeal, by split 2-1 decision, delivered a judgment acquitting Attoforsen and Japa. Ghana is a nation of laws. We have various procedures when it comes to a party wanting to file an appeal against a decision. In this particular matter, it is a considered opinion of the Attorney General. The judgment will have to look at once again by the Supreme Court. And so we've taken possession of a copy of the judgment, we've digested same, and we are putting in place measures to ensure that we file an appeal against this judgment. When it comes to the public backlash, as we say, the wording of the statement that was issued. The statement was issued principally to let the public know the steps that Attorney General will be taking upon the delivery of the judgment yesterday. After all, the Attorney General is not in office acting on his own as an individual. He represents the people. And so any decision that he intends taking, he wanted to communicate to the people of Ghana. This is exactly what was done yesterday.
Right, and I heard the Attorney General speak to us on midday on radio and justify his position. In other words, he still stands by that. And mind you, the PRO of the Ghana Bar Association, by extension, the Ghana Bar Association has said that that was unnecessary. You don't use such language, perverse, inimical to this and that. And especially when you've cited other people, including former President Mahama in the past, for using unanimous 7, unanimous FC, and the rest. People are saying that he shouldn't even address that, conference when the bar meets. Justified, and are you also in support of the language used in that reaction?
Yes, if you look at the text of the release that the AG gave out, it is about his or our disagreement with the judgment, which is within the right of every lawyer so to do. Any lawyer, for that matter, every litigant, has the right to criticize a judgment, but not the judge. So this statement is in relation to the judgment so delivered. I heard what the PR also said on your network yesterday. Last night said, personally speaking, I'm not yet convinced that the AG has done anything to attack the court or a judge. But we are humans. If we are convinced.
But when you attack the court, by extension, what are you saying?
You can criticize a judgment by saying a judgment is unreasonable, is illogical, is perverse, but you cannot say a court. So there's a fine distinction. If you say unanimous FC, it means that you are attacking the court, not the judgment. But if you say that the judgment delivered by the court is unreasonable, it's something that cannot be supported, it's illogical, it means that you are only criticizing the judgment. It's done. But if you cross that line by labeling the court or the judge, that's where the issue comes up. So in the circumstance of this particular matter, the statement is about the judgment, and that's the judgment that we are going to attack on appeal, but not the judges. We cannot do so. We are not permitted to do so, and it will not be done.
I see.
I just want Mr. Tuah to clarify for us, what's the end goal in terms of the objectives of the Office of the Attorney General in this case? You said that the financial loss has been established. You've gone to court. They've appealed, and now they've ruled that there's really no case. If you're going to appeal, what is the aim of that appeal? What are you hoping to achieve at the end of another appeal then?
The appeal is meant to question the judgment delivered by the Court of Appeal yesterday. Or to put it in a different way, the appeal is meant to test whether the judgment delivered yesterday by the Court of Appeal can stand the test of legal scrutiny or not. And so in going to the Supreme Court, we are going to argue legally why we think the judgment cannot be supported having regard to the evidence on record. And if the Supreme Court agrees with that, to mean that the judgment will be set aside and have to come back to the trial court for the matter to continue.
Do you have that hope that the Supreme Court, the apex court, will do that? The Court of Appeal is just a leg beneath the apex court. They are all superior courts, and both sides cited concrete authorities in defending their decision. It's practically the same thing you're going to be putting forth. Do you have any hope?
When it comes to criminal or civil appeals, any appellant will tell you his appeal has a great chance of success. I mean, counsel on this program would just tell you that's what every lawyer will say, that his appeal has a great chance of success. But whether you succeed, it will left to the appellate court to decide. On our side, we think that we left sufficient evidence in the trial court to warrant the trial court calling on the accused persons to open their defense. The Court of Appeal, by 2-1 decision, is saying no, they disagree with the trial court. And so we are going up, where we have other judges also look at the evidence and come to a conclusion of the matter. If we go to the Supreme Court, the Supreme Court comes to a conclusion that our argument is not something that they could buy into and that the Court of Appeal was right, that ends it. And so you go on appeal to canvass legal arguments, but it doesn't mean that you go on appeal automatically you are going to win your case. You can either win or lose. You are minded by that.
And in this instance, I mean, if you lose, then you are triggering your options. You're going to the apex court, which I predicted yesterday. Just a quick ones for you, and then the legal holiday is just around the corner. How do you mean to navigate this? We're practically on the verge of that. 2, there have been calls for the AG not to address the Bar Association meeting. Is he going to comply? And finally, the other ambulance case, the other ambulance case that has come up, I'm sure you're fully aware of that. Is the AG's department going to show the same interest in that case like it has shown in this one? So let's start with the legal holiday and how you plan to navigate it.
Yes, it is true that by close of day today, the superior courts in Ghana will be on legal vacation. But that does not mean that we cannot file our notice of appeal. It will be done in the legal vacation. But as to when the matter will be listed for hearing at the Supreme Court, definitely is going to be after October, either in or after October. So that is the state now. Now, when it comes to the AG addressing the Ghana Bar Association, who determines whether the AG can address or cannot address? I mean, when I hear people making that he cannot address, I mean, it's something that people are just saying it. The AG is the leader of the bar. The AG is expected to address members of the GBA in Kumasi come September. He is going there in September, God willing, to address members of the legal fraternity. And that right is a right that people cannot sit and say you should not go and do it. There's no basis. But that call has no basis. It is only a red herring and nothing else.
I don't think people are saying, I mean, he's head of the bar and he can do what he pleases. But the same way, I guess, Justice Ifiasewa advised him to recuse himself in court, and he went ahead. It's an option for him, but I guess eyes are watching, aren't they? But maybe on the final point.
Who is offering that advice? If, for example, the national executives of the Ghana Bar Association comes out and say they are offering this advice, that's another matter. But if people who have political colors and politicians may want to say, oh, do this and do that, that one, there's no way we have to even give it any form of oxygen. Right. So let's wait for the GEA. You mentioned about the judge. That was a judge. The judge sitting on a matter. But this one, it's not about the GBA, but it's about people who are making pedestrian comments, and they just try to just fly this one in just to muddy the waters. So the AG continues to be the AG of the Republic, and will discharge his duties as the AG of Ghana.
Right. On the final bit about the ambulance.
Ambulance that you said. People should know that the AG doesn't have the power to investigate. And so, if there is any allegation of malfeasance regarding any ambulance procurement, whatever, it is the duty of the investigative bodies in the state to take it up do the investigations, and when they come up with a docket that's prosecutable, the AG will go ahead and prosecute the case as we've been doing with other prosecutions.
Well, it's been exciting, unless you have something else.
I'm still not satisfied with
Deputy AG.
I just want to know what would satisfy you in this case? What would be that thing that says, okay, now we've gotten what we want, and so we are letting go of this case? Is it your aim to simply, jail the accused persons in this case, which now is no case? What will satisfy you, Mr. Tuayewa?
We just want justice to prevail. Have it that it is not only the minority leader who is being prosecuted in Ghana. Other citizens who also pay their taxes are also undergoing prosecution just like any other person. The discussion should not be that because someone is an MP or is a Minister of State or is an MD or is something, he must be treated differently. We at times appeal against decisions of the court respecting other cases. Let's take like Dr. Opuni. Is he not a Ghanaian? When decisions were taken in his favor at the High Court, the AG appealed against it. So does it mean that because he's not an MP and the minority is an MP and there's a decision that we disagree, we should not appeal?
Right.
Okay, so that's a very good point. In just some 10 seconds, the money involved, you have the option, the plea bargain, to get part of that money back. Now, some are saying you've lost that option. If the Supreme Court affirms the decision of the Court of Appeal, it means you would have lost the option of the money, and you've also not secured the ruling that you wanted. I mean, you accept that now, right? That you've lost on both ends.
We've not lost, we as an office have not lost money because there was no conclusion on that plea bargaining proposal. In actual fact, legally speaking, the proposal that came in did not meet the threshold when it comes to plea bargaining.
Okay.
Honorable Innocent is there, my brother Bob Bamson is there. If you take the Plea Bargaining Act, who should initiate the plea bargaining agreement? It is the accused person. But in this case, the Honorable Minority Leader made it clear that he was not interested in any plea bargain. That was his right.
Okay.
A third party somewhere said we should give him some time to pay. I mean, he wasn't part of this kind of prosecution. And so, being officers of the Justice Ministry, we will not overlook the law and do something unlawful. People to come and say, oh, you decide to just ignore the law and do whatever you wanted to do. So, basically, there wasn't anything like we having the money, we rejected it. No.
Okay. Alfred Tuayewa, we're incredibly grateful that you took the time to join us this morning. He's a Deputy Attorney General. Let me bring in Bobby Banton. Inusa Hussaini, please bear with me. I'll come to you. Let me bring in Bobby Banton. You have to take leave of us. What is your appreciation of what you've heard from Alfred Tuayewa in respect of the legal vacation coming up, addressing the bar, and any other final thoughts you may have for us?
I think Senior Tuayewa has said, he's not said anything strange. They have the right of appeal. The time period for filing appeal will still run. That's why the legal vacation, and I'm sure that they will know what to do. If I were in their shoes, I'm sure they would, with all the experience they have, they will make sure they file the appeal, do the necessary service on the parties, and ensure that the record is prepared during the vacation, so that when we come back in October, they would have been ready for the appeal to be heard. So I expect that perhaps by end of year, there would have been the Supreme Court decision, or at least we are sure of a date where the Supreme Court will deliver a decision on this. I think it's in the interest of, for me as a student of the law, to know what the Supreme Court would say in respect of the issues that were set down by the Court of Appeal and how the Court of Appeal had rendered it, from the grounds of appeal, striking out some of the grounds. You know, the Court of Appeal did not, or the majority judgment struck down some of the grounds of appeal filed by Mr. Japa. Those are interesting matters, but because the conclusion was that they were acquitted and discharged, nobody is looking at those things. And so I would want to see how that will turn out in the court. Let's keep focus on the issues so that it doesn't draw into personal vendettas. I hope that it doesn't take those things, because when it does, then it is the confidence of the populace in the judiciary that is eroded. And let's see what the court would say in respect of this.
Bobby, final point. This bit about, so moving it, yes, to the apex court and everything that is going to follow from there. What are your expectations? You have said that it will come through from October onwards. Is there any way of facilitating it, fast-tracking it? Are there any means of doing that?
The Constitution gives the Chief Justice the authority to empanel judges, even during vacation. But that would be in extremely important and urgent national issues. I do not see how this case would qualify for the exercise of that discretion by the Chief Justice. I don't think that there will be any attempt by any of the parties to allegedly facilitate this. Then it will feed into the narrative that there is an agenda to ensure that something happens within a certain period. I do not think that it will make any political or legal or whatever sense that you want to put in would justify why the matter should be heard and facilitated during the legal vacation. I think that we should just go through the normal process and then abide time and see what will come out of it.
My last bit, my apologies. Alfred Tuah cited the plea bargaining, laws that we have, and he made mention of the fact that that threshold that had to be met was not met, which is why they did not accept the sum of money, and also mentioning that Dr. Atoforsen wanted no part of it. Is that how you see it as well? Could we not have taken that money and still gone on with the process like
one essential condition for a plea bargaining to even commence is for the parties, the accused persons, to plead guilty. If you have not pleaded guilty, there's no way the Attorney General can entertain a plea bargain request or arrangement.
Big C was willing to come up with the money, right?
Yes, but Big C was not an accused person. It's still not an accused person. And that is something that maybe if I meet the Deputy Attorney General, I will ask why there was no attempt to make Big C, or the directors of Big C, because even if you are not resident in Ghana, even if you are not Ghanaian, the Ghanaian court would have jurisdiction to entertain criminal proceedings against you if the act was done in Ghana or involved Ghanaians. I don't have the reason why they've not made Big C, accused persons. But if Big C cannot offer, per the law, plea bargaining on behalf of accused persons, that cannot be the position of the law. So to that extent, I agree that the Attorney General, in line with the law, unless they wanted the approach of just, for example, file nolle prosequi or discontinue or withdraw the proceedings and just take the money and walk. But that would not have been going under the Plea Bargaining Act. But because of the publicity surrounding this issue, if the Attorney General had taken that step, just had an agreement, had the money, some money is recovered, and then just discontinued or enter nolle prosequi, as it were, it would have also raised lots of issues. People would have been, that why have you done this? Is it because of the persons involved? Is it because they are able to pay? So I'm sure the Attorney General considered all of those things before they decided to reject that offer.
I'm sure you're also saying that if you were the AG, you would have taken the option of making Big C an accused person in this. Is that what you're saying?
I don't, if perhaps, it's quite, because I don't have the full facts that they have. I don't know why they have not. Okay. So I don't want to say that it is wrong and all of those. Those are questions that I ask myself. Why is Big C not a party? Maybe they can educate us privately or later. Then we'd see how it goes.
Bobby Banton, we're very grateful for your time. Thank you for joining us for this conversation. Sweetie, shall we bring in Inusa Hussaini for his take as well?
Mr. Hussaini, what is your reaction to first the thoughts shared by the Deputy Attorney General, and then you can add your final bits to it?
Well, so you can see clearly from the thoughts shared by the Attorney General to the Deputy Attorney General that they have some reservations. I mean, on the Deputy Attorney General has some reservations on the statement.
On the ruling, right?
Yeah, really, on the statement issued by the Attorney General's office on the judgment delivered by the Court of Appeal. And that is why they issued explanations in order to clear those reservations. Now, clearly, it is the right of the Attorney General's office to file an appeal against the decision of the Court of Appeal, and we could exercise it without saying so, without attacking the court or attacking the judgment. Now, in the recent history in Britain, and during the Brexit, an Attorney General disagreed with the court's decision in ways similar to what has happened in Ghana recently, in yesterday's case. That called for some form of punishment for the Attorney General of Britain for using those harsh words on the court.
Right.
And so nobody will subscribe to an Attorney General behaving in ways that cannot be said to be decorous. And in this particular case, it appears the Attorney General has gone overboard. I agree with Bobby Benson that in this particular case, the Attorney General's action lends credence to the fact that he's drawing himself, he's putting himself at the center of the case. And people are denied the benefit of getting to understand the merits or the merits of the case. And so the Attorney General should do well to remove himself from the case, not physically, but
Mr. Fuseni, he's saying, if you said that he's speaking through the deputy, then Mr. Tuayebo was just saying that they're looking for justice. And that's why the systems are in place so that you can appeal. So until that justice is served, they're still going to pursue this case. So if you're asking him to remove himself...
So the requirement of justice, or the requirement of the pursuit of justice, must be removed from the requirement of seeking a conviction. So in this particular case, it appears to me that the Attorney General is inadvertently putting a conviction ahead of justice, and that is what is lending credence to the fact that this is political witch hunting. And so let's see. I agree again that there are many loose ends in the investigation, in the prosecution, in the dealings of the Attorney General with the accused persons. There are so many loose ends that you need to always ask yourself why this step was not taken, why certain things were done. For instance, the ambulance came in long before the prosecution. What did the state do to mitigate what in their view was lost? What did the state do? And so clearly there are problems. And for me, Atuwa is right in the sense that, well, because the accused persons never pleaded guilty, you cannot go on to, the provisions that deal with plea bargain. And so the accused persons, right from the beginning, have thought that they have not been guilty in this particular matter, and the Court of Appeal has vindicated them.
You're also a member of the NDC, so I'm just going to ask, are you ready to go full-blown, with them if they decide to pursue this case further? You're ready to continue in whatever way that they take this case?
As a member of the NDC and as a lawyer, I've had my doubts since the beginning, and I've not hidden my doubts about this case. And when I was reading the judgment, the majority judgment in the court, I was tempted to believe that I was thinking the same way as the lead judgment of the majority. Because there were so many questions left unanswered. And because those questions were not answered, the trial judge was hard put into inferring from the guilt, from the evidence, the guilt of the accused persons, and inviting them to open their defense. That is what the majority decision deprecated. They said, no, you can't infer, you can't speculate, you can't conjecture. There must be clear, cogent evidence of the probable guilt of the accused person to compel you to invite them to open their defense. And in their view, in the view of the majority, there was no such evidence.
Well, thank you so much, Mr. Unanswered Hussein. You heard the Unanswered Hussein, who is former MP for Tamale Central and also a member of the Legal and Parliamentary Affairs Committee in Parliament. We also spoke to Bobby Banson, a lawyer, and we're also joined by the Deputy Attorney General, Mr. Alfred Tua Yeboah. But before we go, are you stressed out about all your cleaning needs? Worry no more, because Unanswered Services is a one-stop shop that meets all your commercial and residential cleaning needs, from pest control, janitorial and house cleaning, event cleaning, waste management, carpet, sofa, etc. And whether at home or at work, we understand and know how haptic cleaning can be coupled with your busy lifestyle. And we've got great news for you. Unanswered Environmental and Facility Management Services has got you covered. And we excel in whatever we do, leaving you beyond expectation. And you can locate us at Excel House, opposite the Regimental Estate in Nungwa Barrier, or simply call on 0302 905538 or 0555 752361. Unanswered Services, beyond expectations. Ben.
Well, it's been a conversation, and we're moving on. We're going to be talking about the Affirmative Action Bill. Yay. And that latest development, I know you're very excited about it. I am too. Okay. And I'm going to cede to you on that, so we tackle it. All of that action.
Feminist, Benjamin. I know you're a feminist.
Yeah, it's just that nowadays the brand of feminism, brands are not also.
You're second wave, not third wave. You know, we had the first wave, second wave, and third wave. When we get to the...
I'm not a Gen Z feminist. I'm a millennial feminist. We'll be right back on the AM show.